Welcome back to Investing in Intellectual Property with Dave. And I was reading this LeBron James trademark situation or tip that he got himself into, and it's still ongoing. It started a couple years ago, and somebody sued him for $33 million for that. I am more than an athlete. That whole trademark situation, and again, the judge hasn't ruled on it yet. But I thought it'd be good to talk about for a number of reasons from an educational standpoint. But it illustrates a bigger point as far as doing things the right way from the beginning. You know how our parents always said, growing up, a hard head make a soft behind. Well, I think that rings true still today, particularly what relates to this situation. And I actually had a situation that I dealt with many years ago in my earlier days of intellectual property law, coming up on it uh, back actually in college, where the crack chicken. I'm not sure. I'm in Michigan, and crack chicken is a big thing in Michigan, and I'm not sure is it is big in other states, but hey, every Friday, every Saturday, used to go to the chicken spot, and they had this cracked chicken. Cracked chicken pretty much is chicken wings, fried chicken wings that had lemon pepper seasoning on it. But the name cracked chicken, because the chicken was so good, kind of really took off. So I'm at this point I'm in law school, and again I'm going to the chicken spot, and I did my undergrad in law school at Michigan State. So I developed a relationship over the years with the owner of the cracked chicken restaurant. And so I go there and I catch up. Hey, what are you doing these days? And I tell him I'm in law school and things like that. He asks how it's going. There's one particular day, because at this point he knows I deal with intellectual property, and he pulls me to the side and said, "Hey, can you help me out with an intellectual property issue that I have going on, a trademark issue that I have going on?" I'm like, "Okay, let me see what you have going on." So apparently, this guy filed for the trademark crack chicken. He actually got the trademark. He didn't go through an attorney, so he did it himself. He got the trademark. He didn't really follow the steps of what you needed to do to get a trademark. So when you file a trademark and you get it allowed, you have to submit what is called a specimen, showing that you're using a mark in commerce. And he did it, but he didn't do it the right way. So fast forward up until the time where he's telling me about the situation. Another restaurant in the state of Michigan, they wanted again to file for the trademark crack chicken, but they filed for a trademark for the crack chicken, but the guy who is talking to me, his trademark is coming up. But again, the other restaurant, they actually got an attorney, again, just doing things the right way. They didn't try to file the application themselves. They got an attorney to file for the trademark application. And the trademark, once my guy's trademark application came or trademark came up, their attorney essentially tried to file to get that trademark canceled, because again, my guy didn't go through the right steps and procedures when submitting his specimen. So now he's coming to me, he's like, "Hey man, can you help me out with this? They're trying to cancel my trademark." So I'm like, okay, let me see what I can do. So we essentially helped him out with the situation, but it cost him an extra 10 grand just because we had to negotiate with uh, the council. We're trying to cancel the trademark so that, hey, our trademark can still be good, and that the other people. I think I'm not sure if it was a license that we gave them or whatever. I can't remember now, but yeah, we got to resolve. So my guy got to keep his trademark, but again, it cost this guy 10,000 over $10,000, us going back and forth with the other council who was trying to cancel his trademark. When all he had to do was pay an attorney 1,000 to maybe $2,000 at the beginning to file the trademark, get things done the right way. Now he didn't have to worry about uh, people trying to poke holes in his trademark or cancel his trademark later on, because he did things the right way, because he did it with an attorney. Obviously, that's not to say that some attorneys don't know what they're doing, but more likely than not, that attorney is going to have more information as it relates to the subject matter that you're going to him with than what you have. Now, I'm not saying, look, I'm a patent attorney, I'm an intellectual property, copyrights, trademarks. I'm not doing bankruptcy or criminal law. Heck, somebody off the street may know more information as it relates to those subject matters than I do. But when it comes to intellectual property and dealing with NILs and trademarks and copyrights and patents, I would almost guarantee you that I know more than 99% of the average Joe as it relates to those matters. So if you're going to somebody who knows what they're talking about, 9 times out of 10, you're going to be able to kind of walk away in good hands when it's dealing with what you're going for what you're going to that person for. So moving along, how does okay, say Dave, how does this deal with the LeBron James situation? I'll tell you how it deals with the LeBron James situation. So it's a company. Well, let me get the name of the company for you guys. The company is called Game Plan Incorporation. It's a gentleman out of the Maryland area. He back in 2016, he filed for a trademark on I am more than an athlete, but he filed it in a particular class. So what a lot of people don't know about trademarks is it's 45 different classes. So, if you're dealing with clothing, you'll go to the clothing class. If you're dealing with entertainment services, you'll go to the entertainment class. If you're dealing with electronics, you'll go to the electronics class. And just think about it. It's a lot of your famous brands that have that multiple companies own the trademark to. So you have Apple Records that's dealing with a record company, and then you have Apple Computers. You have the Dove, the actual soap brand Dove, which is a trademark to one company. Then you have Dove Chocolates, which is a trademark to another company, although it's the same name. You also have Delta, the airline Delta, which is a trademark to the airline company. But then you have Delta Faucet, which if you ever been through like Home Depots or Lowe's, it's actual a faucet, a very popular faucet company called Delta Faucets that have a trademark on Delta Faucets. So it's not uncommon to have two different companies that own the rights to the name. It all depends on what's the goods and services. Again, airlines, faucets, they're completely two different goods and services. Soap, candy, or chocolates, those completely two different companies or two different goods and services. Apple Records dealing with the entertainment and Apple Computers dealing with electronics. Those are two different goods and services that are being provided so that the USPTO, the United States Patent and Trademark Office, will let those two different companies own rights to the same name. So this guy, again, going back to our case, this I am more than an athlete. The gentleman, or the company, I should say, Game Plan Inc., it filed for a trademark in charitable fundraising services that dealt with charitable fundraising, namely for selling T-shirts. And if you remember, a couple years ago, LeBron James ended up filing a number of trademarks. And I'll just share my screen with you guys here so you can see exactly what I'm talking about. Let's see. Is this it? No, that's not it. That's not the. Okay, here we go. Yeah, right here. So you're looking at the screen here. So more than an athlete, uninterrupted. Obviously, we all know this is LeBron James' company. So in this one, it was for publicity and sales promotion. And you see the goods and services. This is the class 35, publicity and sales promotion. If you look at this other trademark application, it's in class 41, entertainment services. Again, the owners are the same, uninterrupted. Again, this is LeBron James' company, more than an athlete. He then filed a few more that says, I am more than an athlete. This one is in clothing, namely t-shirts, sweaters, hats, jackets, etc. This is 25. I am more than an athlete. This is entertainment services. So then you go down here, you notice these are still pending. So this is to let you know that although he filed the trademark and he filed this a number of years ago, this lawsuit is still ongoing to the point where they haven't ruled on these particular trademark applications. But they did give him a registered application for more than an athlete for publicity and sales promotion. But if you go down here, this is I am more than an athlete. Game Plan Inc. is the owner out of Maryland. He filed it in goods and services class 36, which again, charitable fundraising services by means of selling a T-shirt. So again, once LeBron James' situation started to pick up with the I am more than an athlete, he then slapped LeBron James with a $33 million lawsuit. Now, again, this lawsuit is ongoing, and I'll continue to be on the lookout for it to see how it plays out. But just on the face of it, it seems like they're operating in two different classes. Again, entertainment, services, promotion and sales, clothing, which maybe it's a little bit overlap between his LeBron James clothing class and this Game Plan charitable services as a means for selling T-shirts as a means for charitable services. So that one is going to get a little interesting, but definitely the Game Plan Inc. is not dealing with uh, planning and entertainment services and a lot of these other services that LeBron James is filing a trademark in. So, I think he's trying to, I guess, come up. In my opinion, he's trying to maybe come up uh, on LeBron James because again, let's face it, LeBron James really made this "I am more than an athlete" brand or this trademark, this slogan popular. And it seems like the Game Plan owner, Game Plan Inc. owner, tried to really come up off of it. But again, the bigger part of this whole issue is the Game Plan Inc. He did all this stuff himself. I guarantee you, if he came uh, to me or a trademark attorney or intellectual property attorney and let him know what he was trying to do as opposed to trying to file this application himself, I would have told him, hey, you don't want charity, or you can do charitable services, but if you're selling T-shirts, just go to the clothing category. Don't deal with this whole charitable services class. Just go to the clothing class. If you're selling T-shirts, go to the clothing class. And you can do this charitable service class since you are a nonprofit, but you need to make sure you're uh, uh, protecting this thing in the actual clothing class. Are you doing online stuff? Well, we need to file for a trademark as it relates to online promotional sales. So again, if you go to a trademark attorney or somebody who deals with this stuff, they're going to be able to tell you this, counsel you in a way that you're not getting the short end of the stick. Now you find yourself trying to slap somebody with a $33 million lawsuit. And a lot of people are sitting back, it's like, is this even warranted? He's dealing with classes that you don't even have protected. You protected the "I am more than an athlete" mark in charitable services, where as LeBron is not dealing at all in charitable services, clothing, entertainment services. What was the other one? He had publicity and sales promotion. These are classes that he's operating in that you're not operating in. So again, I think it's going to be an uphill battle for this guy, but he could have avoided all of this if he just would have went to an attorney, a trademark attorney who deals with this stuff. They would have gave him good counsel. So again, the moral of the story is make sure you are going about things the right way so that you don't cost yourself in the long run. Because I'm sure that as with the crack chicken story, it cost my guy extra over 10 grand for us to resolve his situation. I'm pretty sure that this is going to cost this guy, the owner of Game Plan Inc., a lot of money because again, he didn't do things the right way. He tried to do it himself, save money, cut corners, cut costs. I get it. Sometimes we don't have it all. But if you're talking about something that you're trying to build into a multi-million dollar mark, a multi-million dollar company, you need to be able to scrounge up a couple grand. And if you can't, how serious are you? Because again, you trying to do this stuff yourself, you're playing with fire, and this a lot of times it's a coin flip on how this stuff is going to turn out at the end of the day. So hopefully you guys got something out of it. If you did, like the video, leave a comment, subscribe to the channel. If you didn't like the video, still leave a comment. Let me know what you didn't like about it. And again, just trying to provide you guys educational, informational of things by way of real world examples so that going forward, when you start to get into this world of intellectual property, which is a valuable, extremely valuable world, you're making sure you're using these as case studies to go about things the right way. So until next time, I'll catch y'all later. Peace.